Yeah, so thank you so much for having me here at the Chicago WordPress Meetup. I've lived in Chicago for quite a while, so it's really nice to see everybody. I was at the last meetup, and I really wish we could have had the WordCamp Chicago as well, but probably for the best that we didn't. But I'm very happy to see everybody here. And today I'm going to talk to you about the 3 things all web professionals need to know about privacy. And before I start on that, I just want to say that privacy can be an intimidating topic for some people, just because it feels like there's so much that you need to know, and so many different rules and regulations that you need to be an expert in. And I just want to let you know that's really not the case. So we'll kind of go through the basics of what privacy means online, what does it mean to you as a web designer, as a web developer, as a web professional, and really just the basics that you need to know about privacy. And if anybody has any questions, feel free to ask, whether in the chat, and I'll be sticking around after the presentation as well, so you can ask me anything at that time. But I really wanted to say that, regardless of where you're located, whether you're here in Chicago, in the surrounding counties, whether you're in Indiana or whatever, privacy is really starting to become a big deal, and privacy rules and regulations will affect you and your clients, regardless of where you're located, just because of the nature of the internet, where people can go from any country and visit your website and submit their personal information. So it's something that's going to affect everybody, regardless of where you're located right now. And my goal today, and hopefully in the least boring way possible, is to talk to you about 3 things. So which websites need to have a privacy policy so you can quickly spot a website that you're building that's going to need one, why privacy policies are important, and why you should be the one to talk to your clients about privacy. So before we get started, let me introduce myself and why I think that I'm qualified to speak to you about this topic. So again, my name is Donata. I'm a data privacy and technology attorney. I'm licensed in Illinois. I'm also a certified information privacy professional and the president of Termageddon. And Termageddon is a privacy policy terms of service generator, and our policies are on thousands of websites now. So it's something that I'm very passionate about and proud of. We actually just launched Canada compliance about 2 days ago. Which was very exciting to, I'm sure, no one but me, but that's fine. So really what I do as part of my job is I keep track of privacy bills and laws all over the United States and the world now, including case law, and I make sure to update our clients' policies whenever the laws change. I'm the chair of the International Association of Privacy Professionals, Chicago chapter. If you ever have any questions about privacy, IAPP.org is the place to go. They have everything from white papers to videos to conferences that really have some really great material on privacy and what privacy means in today's world. And I'm also the newsletter editor for the e-privacy committee of the American Bar Association. So I help American attorneys keep track of privacy law developments here in the US and across the world. Now, maybe not exactly related to privacy, but I'm also a beekeeper, and it's something that I'm super passionate about, and this is me and my bees. So also, if you have any beekeeping questions, let me know. I'm probably the wrong person to answer your questions because this is only my 2nd year, but it is a lot of fun, and I definitely recommend it. All right, so what websites need to have a privacy policy? There are a lot of misconceptions here. So a lot of people will think that, only websites that do e-commerce need to have a privacy policy, or only websites that share personal information or sell it need to have a privacy policy. And that's really not the case. So the first thing that we're going to do is be able to pick out which website that you're building needs to have one. So we only have one definition here because I tried to keep those at a minimum as well. But really any website, oh, I'm sorry, what is personally identifiable information? This is one term that you really need to know. And personally identifiable information, or PII, is any data that could potentially identify somebody. So examples would be name, email, phone number, or physical address. So when you're building a website and you're building a contact form, you can see how that contact form collects personally identifiable information, or PII. Or a website that has a newsletter sign up form, or a checkout form, or make an appointment page. All of those forms collect personally identifiable information. So if you remember nothing else from this talk, I would really encourage you to remember this one. Any website that collects PII needs to have a privacy policy. And basically what that means is any website that has a contact form, newsletter sign up form, billing portal, checkout forms, appointment setting forms, all of those websites need to have a privacy policy. So if you're building a website that has a form like that, that's when the light bulb should go off in your head, basically saying, this website probably needs one. So why does PII collection and privacy matter? When I was a kid, I would not do anything unless I understood why. And I feel like I still carry that to adulthood. And I feel like a lot of people do. Like, if I just tell you, oh, okay, that needs a privacy policy, and you don't know why, that doesn't mean anything to you, right? So next, we're going to explain why should these websites that have forms have a privacy policy and what that means. So the collection of PII matters because privacy laws regulate the collection and use of PII. So notice that I didn't say sharing or selling. So while privacy laws do govern that, privacy laws will start to apply to a website as soon as you collect the PII. So it's not sharing, it's not selling, it's not using. If you collect it, that's really the time in which privacy laws can start applying. And basically what privacy laws say is that consumers have or need to have the ability to make an informed decision about what's being done with their data. So privacy laws really require websites to make certain disclosures. So for example, what PII is collected, what you do with that PII, and who you share that PII with. And these required disclosures are made in the privacy policy. So that's what a privacy policy is. It's a document that contains all of the required disclosures that are required by law to enable a consumer to make an educated decision about whether or not they want to provide their personal information to that company. Now, just to be clear, there are a lot more disclosures that privacy laws will require than these three, but these are kind of just the meat and potatoes of a privacy policy. So when I say privacy policy, that's usually what people think of is that information. And each privacy law will have, different requirements for what a privacy policy needs to disclose. All right, so we have some laws that protect personally identifiable information when it's collected by websites. So the first one, the General Data Protection Regulation, that one is the European Union law that I'm sure most of you have heard about. Everybody was freaking out about this a few years ago and have continued freaking out about it. But GDPR will generally apply to companies that are located in the European Union. Businesses that offer goods or services to European Union residents, regardless of that business's location, and regardless of whether or not payment is required to receive those services or products. So for example, if you are, I don't know, advertising lamps and you're located in Chicago, but you're selling them all over the European Union, you ship to the European Union, you provide your website in German or whatever language, that's when GDPR would apply. And also it applies to businesses that monitor the behavior of European Union residents, regardless of that business's location. Next, we have the California Online Privacy Protection Act of 2003, or CALOPA. That one's a little bit older, but it applies to any website that collects the personally identifiable information of California consumers, which basically means any website in the world, right? Because a person from California could just go onto your website and fill out their information and submit their information, at which point the law would start applying. The California Consumer Privacy Act, this one's new. It went into effect at January 1st of this year, and it will start to be enforced by the California Attorney General on July 1st of this year. Really interesting tidbit, a bunch of groups asked the California Attorney General to delay the enforcement date of this law because of COVID, and he said no, so that's fun. I'm not sure how companies are going to be able to be prepared for this, but it did go into effect earlier this year, and we've already seen multiple lawsuits under it because it allows consumers to sue under certain circumstances. But basically, it will apply to any business that is for profit, that does business in California, and has annual revenues of 25 million, annually buys, receives, sells, or shares the PII of 50,000 or more California residents, or derives 50% or more of its annual revenue from selling the personal information of California residents. So this one by statute applies to larger businesses pretty much, right? But if you're acting as a vendor for a larger business, especially having access to their customers' personal information, you might be required by contract to comply with that law. And then also we have the Nevada Revised Statutes Chapter 603A, which was recently amended. And that basically applies to any website that enters into a transaction with a Nevada consumer, or has sufficient connections with Nevada or does business in Nevada. So if you're a business located in Chicago, but you are building websites for Nevada customers, at that point it might apply to you. Also, if your clients have e-commerce stores and they sell all over the US, including Nevada, they need to make sure they comply with that law. And we also have the Delaware Online Privacy and Protection Act, which applies to anybody collecting personal information of Delaware residents. One thing that I would want to note with all of these privacy laws is that their purpose is to protect the consumers of that state, not the businesses, which means that they have very wide application throughout the United States. So if you're collecting personal information from people in these states, if you're doing business with them, if you're selling products or services there, you really need to make sure that you're complying with all of these, or whichever ones apply to you. So just because you're located in Chicago does not mean that the California laws don't apply to you or that the Nevada laws don't apply to you. They really can. It's just the nature of the beast of privacy law and privacy law legislation, is that the laws can apply to businesses outside of that particular state. Now this is a fun one. This is our state privacy bill tracker, and you can find this on our website, termageddon.com, on our blog. And basically what it is a grid that tracks all of the proposed privacy bills across the United States and what each of them mean and what each of them require. So after the whole Cambridge Analytica scandal happened, that's when consumers really became interested in their privacy rights, which at the time they didn't have any, and we still don't have any in many states, including Illinois, when it comes to most personal information. But basically, the whole Cambridge Analytica scandal made consumers more aware of how their personal information is used, misused, and abused online. And that kind of started a whole movement where a lot of consumers were calling their legislators saying, we want more privacy rights and we want you to pass privacy laws. Because as an Illinois resident, it's kind of unfair that somebody from California gets all these rights and I get nothing. So what we saw is a whole bunch of states coming out with their own privacy bills and privacy laws. We were hoping for a federal law from the privacy side, but that is not really happening. So what we have is all the states coming up with their own rules. Now, there are some some commonalities between these. So all these can apply outside of state lines. They don't just regulate the businesses that are located in that state. All of them would require websites to have a privacy policy with very unique requirements for what that privacy policy needs to disclose. So for example, if you take the existing California laws, they require you to allow consumers to opt out of the sale of their data, and you have to provide them with an email and a telephone number of how they can do it. Meanwhile, Nevada's law requires you to just state whether or not you sell data and then allow them to opt out of current and possible future sales. So it's really complicated as to what each of these laws require in terms of disclosures, which is what makes this tracking kind of difficult. And you know, some of these bills have a business size exemption, so they would apply to large businesses only, while other ones don't. They would apply to any business, regardless of size, regardless of where they're located. So if you can see, Illinois actually has 3 proposed bills right now. So it'll be very interesting to see which one of these pass and what happens. But if I can just go through the grid real quick, consumers can sue. That means that some states would allow consumers to sue businesses directly for violations instead of having the Attorney General enforce. And we saw that with Americans with Disabilities Act lawsuits. Consumers can sue businesses directly, which usually means there's a lot more lawsuits that are going to happen if that's the case. A lot of these laws allow consumers to access the data that you would hold on them, as to delete their data, as to correct data that's not correct. Restrict processing means that you could use data for certain purposes, but not for others. So for example, you could use their payment information to process a payment, but you couldn't use their billing information to send them newsletters or something like that. Right to opt out would mean the right to opt out of sales of data. Opt-in consent required. That means that they would actually have to consent to you taking their data and using it. Right to portability. That basically means that you would have to package that data up and send it to whoever they need it sent to potentially your competitor. Against automated decision making. Automated decision making is making decisions through technical means only, without any human involvement that has legal repercussions on a person. Fiduciary duty is the duty to use data to the best of your ability and make best decisions when it comes to that data. Prohibits discrimination, means you could not discriminate against people who exercise their privacy rights by charging them more or giving them goods that are of lesser quality. And right to be forgotten, basically you would have to take that data and take articles out or something like that that are about that particular person. So we see that a lot with companies like Google, of people asking Google to delist articles that are potentially negative about that person. I don't know how well that would fly here with the First Amendment, but it has flown in the EU before, so who knows. And this grid is actually, I actually end up updating this grid probably 2 or 3 times a month because things change so frequently. So earlier this year, we started off with a completely different grid. And it's interesting to see that things have not slowed down that much, even though they have slowed down a little bit in the legislative area, but the privacy laws that are in effect are still being enforced. So in terms of, what happens if you don't comply, I think that some people may think, all right, there's privacy laws, but what's going to happen if I don't follow this, if I don't have a privacy policy, if I don't tell my clients about it. So penalties for not complying can range from $2,500 per violation to 20 million euros in total or more. And in terms of per violation, that does not mean per website, it does not mean per policy, it actually means per consumer whose privacy rights you infringed upon. So let's say you have 100 website visitors from California a month, and you're not complying with that law, that would be 2,500 times 100. So even for websites that are not that popular and that many people don't visit, that can really add up. Now, in terms of how likely it is that somebody will be fined for this, especially a small business, what we saw in Europe, I think is very demonstrative. So the European Union has GDPR as their privacy law, and you're more than welcome to Google search GDPR enforcement tracker, and it will actually lead you to a list of cases. And there's over 200 of them, and you can review all of them and see what those were. But we have seen small companies being fined. So for example, a small company was fined thousands and thousands of euros for changing the email of a user in their CRM without getting that customer's permission. We've seen one-person marketing companies getting fined. We've seen companies getting fined for abusing the privacy rights of one person. So you don't necessarily have to be a large company, nor do you have to have a lot of users or a lot of customers to be fined. What they're really looking for is violation of privacy laws, and that can be really easy, easy to come by. So it's something that I would definitely keep in mind. Just because you're a small operation or your customers are small, that doesn't mean that you may just escape regulator scrutiny. Now, for those of you who don't care about fines, there are a few other reasons to care about this. And even if you want to roll the dice on fines, this is something that you shouldn't roll the dice on. So a study by Cisco found that 70% of organizations say they receive significant business benefits from privacy, including decreased likelihood and costs of data breaches. A study by Amnesty International found that privacy concerns are having a major impact on people's online behavior. There was a recent study saying that about 52% of Americans will leave a website or a platform if they feel like their privacy rights are not being respected. So it's something that consumers definitely look out for a lot more than they used to. I remember, 5 years ago, nobody read a privacy policy except for me. And that's just really not the case anymore. Consumers are trying to make sure that they're providing their data to responsible companies. And if they feel like a company does not respect their privacy or is not responsible with their PII, they're going to leave that platform. And then a different study by Cisco found that privacy concerns can slow down the sales cycle by an average of 7.8 weeks, which is a really long time in a small business setting. I don't know about you, but I would not want to, delay my sales cycle by almost 8 weeks. I mean, that's crazy. So, privacy is a great way to prevent these kinds of things coming up. And then also, I think that as people, as consumers ourselves, we can all agree that caring about privacy is the right thing to do. We care about our own privacy. We want to make sure that our own privacy is respected. And we all can tell when we're getting, marketing messages, text messages from a new number, or somebody adds us to a mailing list where we didn't want to be on that mailing list, or we don't even know who that person is. It's just an unpleasant experience, at least in my opinion. I personally don't like being added to email lists that I don't know who you are. We've never met. I've never even spoken to you. And now you want me to become a Bitcoin miner. Like, I'm not doing that. So I think, as people, we can understand that caring about privacy is the right thing to do. And I think as business owners, we have that ability to step up and to be a positive role model that cares about privacy. So lastly, I'm just going to have a sip of water. As our last topic, let's talk about why you should be the one to talk to your clients about privacy. So you build websites, you design graphics, you perform marketing. Why are you the one that should be talking to them about privacy? Isn't that something that, their lawyer or their business advisor or their business partner should do? Why is this your problem? So the fact is that clients see you as a guide to all things online, regardless of their experience, right? They're turning to you to build them a website, help them with marketing, maybe even help them with email, or, all of those things that they're less experienced about. So they might not know about this privacy stuff. So they might just be thinking, okay, we're building a website, great. All I have to do is pay you, and then, launch the website, and then we're good to go. What they really might not realize is that not having a privacy policy on a website that has forms can open them up to a lot of liability. Now, that doesn't mean that you have to be a lawyer and talk to them about contracts, limiting liability and other legal stuff. Really, in my opinion, all you need to know is that this website has a contact form, it's collecting PII, that means it needs to have a privacy policy. And your conversation with your clients does not have to be any more complicated than that. You can just tell them, hey, I'm not an expert in this, but I really think you should speak to an attorney, or I really think you should look at a solution for getting a privacy policy on your website, and get that documented as well. But in terms of why I think that you should tell your clients about this, it can make you look proactive and professional. Privacy is definitely on the cutting edge of the web industry. It's been around for a few years, but it's definitely becoming more and more important as time goes on. And it's an industry trend that we're seeing, that we're going towards. It can help you stand above your competition. So other agencies that are not thinking about this stuff, if you put two different proposals together, being able to show yourself as a business-minded person who is well-rounded on all the things websites, including compliance, can really help you stand above your competitors who don't talk about this. It can help improve client retention and loyalty if you're providing them with good advice. And it can also help document this and protect your agency. One thing that I wanted to make sure that I touch on is the fact that as the number of privacy lawsuits increase, businesses are going to need to or want to start blaming other people for their shortcomings. So really at the end of the day, it is the business's responsibility to make sure that the website is compliant with all applicable laws, rules, and regulations. That's not your responsibility per se. However, you should really make sure to check your contracts and make sure that you're not guaranteeing any kind of compliance in there, and make sure that you have airtight contracts with your clients that make it clear that they're responsible for making sure that their website is compliant. One thing that I would also say is if you do decide to have a conversation with your clients about privacy, you should make sure to document the fact that you talk to them about it, even if it is just in an email, just saying, to recap, we discussed getting a privacy policy for your website and that your website might need one and that you should seek out advice or seek out a solution for your privacy policy. And I think that that's a very, very important thing to document as we see more privacy lawsuits, as we see more privacy infringements and fines being imposed. You want to make sure that your clients can't blame you for their own failing to make sure that their website is compliant. So when should you tell your clients about this? There are a couple different places where, it's kind of natural to bring this up. So first, when quoting new projects, usually quotes will include a number of pages and the types of pages that there are. And, we're going to build a contact form on your contact us page. That's a great time to talk about this because it's a great time to show that you're proactive. It's also a great time to include a quote for putting together a privacy policy page or a terms of service page and copying and pasting the text in there. Because those pages need to be styled as well. Before launch, so when a website launches, that's usually when they'll start collecting personally identifiable information. So before launch is really a great time to tell them about this because that's when, is a great time to become compliant before you're already out of compliance. In maintenance plans, I see a lot of agencies adding a privacy policy service into a maintenance plan as an additional add-on or as a value add or an additional charge. And really anytime, right? So this is something that's relatively new. It's something that's really important to your clients, hopefully, even though they might not know about it yet. So, anytime you can talk to them about it, it's a great time to bring it up just as an additional conversation topic as well. All right. And then where can you get privacy policies? So there's really two different places where, privacy policies can be written. One is attorneys. So privacy attorneys can write privacy policies for you or for your client. Make sure that you're using a privacy attorney, not just a general business attorney. Privacy law is a highly focused field, and there's a lot of laws and bills and regulations, as you just saw. So make sure that whoever you're using is an expert in their field. One great way to weed out the experts between the non-experts is ask them what their strategy is for keeping your privacy policy up to date. If they ask you why would it need to be up to date, or if they're telling you that they're going to charge you an extra $2,000 every time it updates, that should really be a red flag. I can say we updated our privacy policies, I think 3 or 4 times in the last 6 months. So if you're getting charged extra each time that they're updating the policy, that can really add up throughout the year because privacy law is changing so frequently. So really, attorneys are a great option for larger clients or for clients who can afford to pay the cost of an attorney, which is probably a couple $1,000s for a privacy policy. And it's also really good for clients that need special compliance. So for example, clients that need HIPAA compliance. So your doctor clients, your dentist clients, stuff like that. Or clients that need financial regulations. So if you have a client that's a bank, that's a great time to hire a privacy attorney to create their policy. Now, attorneys can be unaffordable to some smaller businesses, and I think generators are a great second option. So generators are usually quicker and more cost-effective solution and work really well for the majority of your clients. And maybe I'm a little bit biased here because Termageddon's a privacy policy generator, but I definitely think that most small business websites that have a regular contact form, a regular newsletter form, can get away with using a generator to get compliant. Here's my contact information. If you do think of any questions after the talk, or tomorrow, I feel like I always think of a question right after the conference ends. So if you're one of those people, which I totally am, here's my contact information, and you can send me any questions about privacy. So yeah, I think that's it for my presentation. Should we go into questions?
Yes, so there was a few questions on the chat as you were speaking. Robert first asked about analytics. He just writes analytics question mark, maybe wanting to know. He's coming back on the scene.
So that was early on, and Donata was talking about if you have forms, you're collecting that information. To what degree does it matter if I'm collecting even simply just Google Analytics? Do I need a privacy policy around that?
Yeah, so two sides of that, right? So number one, Google's terms of service. When you're installing analytics, you agree to their terms of service. And that's when they require you to have a privacy policy on your website. So it is required by Google's terms of service. Number two, analytics will collect IP address, browsing history, and history on interaction with a particular website. And because that's tied to an IP address, that would be considered personally identifiable information. So if you have a website that has Google Analytics installed and nothing else, like you have no forms, no signups, no nothing, you're still collecting PII in that case, and you would need to have a privacy policy.
Good to know. Thank you, Nana.
Yeah, of course.
I don't know, Steve, if you want to hop back on and ask your question, but he posts, when you say business, do you mean all websites, or does it exclude personal ones? In other words, blogs. Okay.
Yeah, because you were talking a lot about businesses.
Yeah, so privacy laws regulate commercial websites. So if you are engaging in commercial activity, that's the case. That's the time when you would need to have a privacy policy. So if I have a blog that I share recipes on and I don't have like affiliate links or anything like that, I can get away with not having one because that would not be considered commercial activity. But if it's a blog that drives traffic to a business, or it's a blog that's driving traffic to like a consultant or something like that, at that case, that would probably be considered commercial activity and you'd need a privacy policy.
Okay, there's a question from Brian. When updating a privacy policy, do you have to email customers each time?
Depending on what laws apply to you. So for example, if the general data protection regulation applies to you, you need to have consent if you're processing data based on the legal basis of consent. And that's like a whole another thing that we won't get into. But if you are adding additional purposes for processing data, you will need to get consent again. So for example, I have a website where GDPR applies to me and I send email newsletters, right? And that was in my original privacy policy. That's what I got consent for. And now I want to use that personal information to, let me think. I want to use it to, what's a good thing? I want to use it to send it to advertisements, right? I would need to get consent again for that specific purpose. So just because I got consent for a different purpose in the past, that doesn't mean I can just use data however I want to. But that's GDPR. Most US laws don't require that. It really depends on what laws apply to you. So some laws will actually require you to only state how you will notify users of your privacy policy changes. So for example, I'll send an email or I'll put this on my website or something like that. And some state laws don't even require you to do that. So the answer to that question really depends on what laws apply to you.
Great. Okay. And then Paul asks, with the various regulations, are there any differences for nonprofits or apply to all organizations without regard to profit nonprofit?
Yeah, some laws will exempt nonprofits. So for example, the California Consumer Privacy Act, the new one, that actually does exempt nonprofit organizations. So again, you would have to check law by law basically as to what would apply to you. But most laws will exempt not-for-profit organizations, yes.
And I had a question. Do you, when someone is using your generator, how does it work as far as, do you take into account what I do on my site and then you generate a flavor of privacy policy, or is it just a massive blanket privacy policy that?
I like want our developers to count this, but I think there's over like 100,000 combinations.
Right, okay.
So what it does is you log in and it will ask you questions about your website. What information do you collect? What do you do with it? Who do you share with? And then depending on what laws apply to you, it will move to different questions because different disclosures are required by different laws. And then it uses that to pull language based on what applies to you and what you selected. So it is customized.
Great, okay. And two questions coming in from Whitney. Is there a generic policy that will cover all policies?
I have never seen anything like that before. So it's probably like the holy grail end of the rainbow, right? It's like what all of us want. Like, I just want one thing and I just don't want to worry about this. Unfortunately, it doesn't work that way. So each privacy law requires very different disclosures to be made. So, and you need to figure out which laws apply to you first. So for example, I see a lot of people using templates that are privacy policy templates. What they don't understand is that that privacy policy template includes GDPR, which requires you to allow people to request to delete their data off of your system. Deleting data from all of your systems is a very time-consuming and expensive process for most people. And then you also get data subject requests and you need to respond to them within a certain number of days and you need to include this information, and like the requirements go on and on and on and on. And if you use a template that complies with a law that you don't need to comply with, you are setting yourself up for a lot of work in the future because you're providing people certain rights and you're imposing certain obligations on yourself. So don't comply with laws that you don't need to comply with because it's going to cost you time and money, and you'll probably have to hire a lawyer to respond to requests if you're not well versed in how to do so. So I think, the holy grail template that, applies to everybody, it doesn't exist because different websites use information in different ways and they share it with different people. And taking a template that is very blanketed does not do the consumer any good because it will be confusing because it won't apply to what you're doing. And then second, it can be a deceptive and unfair practice. And that's from the Federal Trade Commission. So they've seen people take blanket privacy policies and put them on their website. And then it turns out that privacy policy said that you were going to comply with the US EU Privacy Shield, which is an extremely complicated privacy law. And then you don't actually comply with it because you just copied and pasted something. So it's just not a good idea all around. And a blanket privacy policy, I don't think that could ever exist.
Great, thank you. And then a follow-up from Whitney too is, can you expound on all rights reserved text that's usually found or in the footer of websites?
Sure. So that's more of a terms of service question. Terms of service will usually specify that all content, all images, and all links and all text is owned by the company that owns the website or the person that owns the website. And, that's a great way to deter copyright infringements and copyright thefts. I think, your footer should say copyright year from the date that you started your website to now, in terms of years, not by day. And then, enter your company name or enter your name. I think one thing that a lot of people overlook with a terms of service is what's called a Digital Millennium Copyright Act notice. Which will actually help you reduce the number of copyright infringement claims that you could get. So basically what that notice says is, everything, we own everything here, but if you believe that we were infringed on your copyright, please send us a message here. And basically what that does is it encourages people to talk to you instead of just filing a lawsuit in the first place. And you can make most copyright claims go away that way. And the law will actually provide a safe harbor for you as well. So I think that's a really important part of terms of service that's often overlooked, is the ability to, not get sued for copyright infringements.
Great, thanks. And Nina asks, is the privacy policy specific to the actual website it is on or to the parent business that might have other unrelated websites? She has a client who is worried that the policy needs to cover everything the parent organization is doing.
That's more of a choice to me. So in terms of what privacy laws are meant to do, they're meant to provide consumers with transparent and adequate information as to what happens to their personal information on that particular website. So if I go onto a website to buy a wedding dress, and you collect my name, email, and phone number, it's going to be very confusing to me if on your privacy policy, you also say that you collect name, email, phone number, education information, work information, analytics information, and that you sell my data, even though the particular website that I'm on doesn't do any of that. So to me, to make sure that the privacy policy is the least confusing and the most accurate to that consumer, I would probably do it by the website. But that really depends on how their business is structured. Obviously, I don't know any of that information. I would just say that you should strive to make sure that your policy is the most current, accurate, and relevant to that particular website and what that consumer is doing on that website.
Great. And then I think that forgive me if I've missed one, but I do think that covers all the questions in the chat. If we wanted to, I don't know, Robert, if we want to open it up so we can.
Yeah, I'll stop sharing my screen then.
Okay, sounds good.
Awesome.
Great. Any questions?
Any other questions?
I have a question, but I think I already know the answer to this. But that being said, okay, so technically, I'm one of these guys that does this, so bear with me. Technically, if I have a small website with a landing page, right, and there's no contact form, it goes to an email address, right, and any payment processing is done through like PayPal, I'm not technically collecting any data externally unless I was using analytics.
Are you using analytics?
Let's just say I'm not. I'm just throwing a hypothetical. Yeah, I know. So yeah.
Of course you are. How could you not be using analytics?
Not necessarily. Well, that's true because yeah, I mean, if you're sending ads from like a Facebook, you're gonna be stuck with like a
Yep.
pixel analytics. Yeah, it'd be really hard to do that, I guess.
Well, let's say you're not, right?
Yeah.
Technically, I'd be hard pressed to say that you would actually need a privacy policy if you're not collecting any personal information. However, the Stripe, sometimes settings will be set the incorrect way so that the website and Stripe is actually collecting personal information. So definitely make sure that it's not doing that, because then you need PCI compliance, which is horrible. I would say for that website, I would still have a terms of service though, because you are taking users to a different website, namely PayPal, and you want to make sure that your website is not liable if PayPal's data is breached, and that consumer's information is stolen.
Got it.
Well, and the other thing is PayPal knows where that purchase is coming from. So that's your site. And they're tying that directly to an IP address of the customer. So
Yeah,
certainly
PayPal's doing that.
PayPal.
Yeah.
So PayPal certainly has that, PII. It's just one of those things,
Usually
CYA.
usually terms of service will state that, we use a third-party payment processor to process your payments, because some users might not be savvy enough to understand that Stripe is a different business.
Cool. I'm sorry. I just wanted to. So I guess this whole started from the question of, let's say I don't use a contact form and I have just an email on my website to contact me. Should I still advise a client they would need a privacy policy for a situation like that?
If they don't have Google Analytics?
So I would need to because of analytics, right?
Right. Yeah, but
even though analytics is anonymized data, technically.
Yeah, it still counts though. But if you're not using analytics, if you don't have any forms, if you're not collecting any personal information, then you don't need one. Yeah.
So
I think Scott's question was, I have a blog and you can email me from the blog and you click the link and it opens up your mail client.
Yeah.
It's not a form. It's
Right.
just a link, mail to link.
Yeah.
Do I need, TOS and privacy policy because they've clicked a link that opens up their email client to email me?
No, so you wouldn't need a privacy policy in that case. You should have a terms of service anyway, but you would not need a privacy policy.
Yeah. I guess this all stems from the fact that a lot of times too, it's not just about advising the client that they have to go get a privacy policy. We also find ourselves advising clients that they shouldn't be retaining this type of data, or they shouldn't be doing this type of digital business activity because they don't want to even have to go down that road kind of thing. We don't want to use I might say, hey, we don't want to do that just because then that's going to put us in the, for example, with some of the clients I have, with my job, Ticketmaster's handling the transactions, right? So Ticketmaster is really in charge of their privacy policy and their stuff. And it's clearly stated in the process. They go from our website to Ticketmaster, so that's just, there's a lot of things we don't want to do that. We don't want to sell tickets on our website because one, we're in a contract with Ticketmaster, but two, we wouldn't want to take on that privacy policy situation. So that's just my thought. By the way, so technically,
right?
Yeah.
Some people might just not want to have a contact form then, but that's really their choice to make, right? So if they know that they need to have a privacy policy and they say, all right, I just don't want a contact form, then that's up to them. That's okay. Personally, as somebody who used to work in a web development agency, I don't really see the point of a website without a contact form for business, but that's just me.
Yeah.
I would say in terms of service, I would have that for websites that link to other websites, because you can actually get sued. So if I go to your website and I go from your website to PayPal and I get hacked, I could potentially sue you as the original website owner because I came to your website from PayPal. And terms of service will help prevent that from happening. Same thing also with copyright infringement, great for avoiding copyright infringement, and then also for choosing the venue for resolving disputes. So if I'm a New York resident and I go to your website and you're in Chicago, if I sue you in New York, that's obviously going to be a pain for you because you're going to have to travel to New York to do depositions and evidence and such. In terms of service, you can actually say, I want to resolve disputes in Cook County, Illinois, and they would have to come to you. So that's another reason why terms of service is helpful. So I see privacy policies as more like what's required by law, and then terms of service is more like what gives me benefits as a website owner. So terms of service is not something that should be overlooked too.
Yeah. And I just want to be clear. I completely agree and like support everything you do. I'm grateful that there are services like yours. I just know like I've got a lot of clients that are always trying to get around. They're always trying to get around things, and they're always trying to say, they don't need this, they don't need that. So it's like I'm always trying to be like, well, you need this because you do this type of data collection, do this. So everything was super helpful. Thank you so much for sharing.
Of course. And even if you disagree with me, that's totally fine. Like, you can have a debate. There's nothing wrong with it.
I don't disagree with you. I just know that that's
but I would say, like, from a web agency perspective, you know, if you tell your clients and they're like, no, I don't want to do this, like, I'm fine, I'll get sued, I'll get fined, I don't care. That's up to them at that point. Like, you did your thing, you told them, you said your piece, and then really as a business owner, if they want to get fined or if they want to roll the dice, that's up to them.
Mm-hmm.
You know.
Two questions, Nada. You just totally inspired me there. So one, I'm going to forget the second one already, but the first one is, if I, as an agency, don't tell my client that they should have this, am I liable?
It depends on what your contract says. So a lot of agency contracts have a lot of errors in them. So before Termageddon, I actually used to write contracts for agencies. And review their existing contracts and make changes to those contracts. And the amount of contracts that I saw that said, like, we guarantee your website to be compliant, or we guarantee that this work will be conducted in a professional and workmanlike manner. And, you know, if your contract says to your client that you're responsible for compliance for that website, you need to tear that up and get a different one. So if you have that in your contract and you didn't say anything to the customer, you would be responsible for that. And, you know, you could get sued for that if your client gets sued or fined. If your contract says that you'll do work in a workmanlike and professional manner, consistent with standards in the industry, basically you will be compared to other web developers in their area and whether or not they tell their clients to get a privacy policy. So if you're in Chicago and most web developers in Chicago tell their clients to have a privacy policy on your website and you don't, you could be liable if that's what your contract says. So it really depends on what the crowd says at that time. So that would not be good. If your contract is good, if you made sure that you don't provide warranties, if you made sure that you don't say that you're going to be liable for compliance, you know, I don't know. At that point, probably not. But, you know, we've seen what happens in courts, right? So for me, in my opinion, the best thing to do would be to make sure that your contract is airtight, number one. And number two, to make sure that you tell your client and that you document that in writing. That's really the safest way to go around, even if it's just an email or something like that, just so you can bring it up and be like, yeah, I told you about this and you refused to do it. But really, at the end of the day, unless your contract is bad, you know, the business is responsible for compliance. So, you know, if you tell them, if you document it, if you have a good contract, I wouldn't worry about it too much, to be honest with you. But I would definitely make sure that my contract is good.
So then the second question, which I did actually remember, is, do terms of service or privacy policies mitigate my exposure with regards to the Americans with Disabilities Act, ADA, website development, or anything like that? Or do I still need to do that kind of development
It's
on the
completely
coding
separate.
side. Okay.
Yeah, it is completely separate. So having a privacy policy or terms of service would not really protect you in that case, because it's not something that you can contract out of. So same thing with privacy laws, right? So you can't put in your privacy policy that the user agrees that we're not going to follow any privacy laws and that we're going to do whatever we want with your privacy policy, which I have seen that, by the way, which is insane. You can't do that. Privacy laws will actually prevent you from doing that. Same thing with the Americans with Disabilities Act. You can't just sign a contract and waive your rights. You need to make sure that that website is accessible to people with disabilities, and that's separate from having a privacy policy. A terms of service can help you limit your liability in case of a dispute regarding your website, but it's not a stopgap. It's not a full solution. It's maybe 10% of what would help you, with the rest 90% actually making the website accessible.
Thank you. Thank you very much.
Donata, another question has come in. Do you have any comments about cookies? How does this affect things, particularly if your website collects a lot of them?
Yeah, so cookies is something that's very relevant if you need GDPR compliance, or if you need compliance with Canada or Australia laws. US laws do not actually require you to have a cookie checkbox. It's kind of debatable with the California Consumer Privacy Act, what cookies are going to look like, because we're still waiting for Attorney General guidance, even though the law is going to be enforced starting a month from now, so that's fun. But they're saying that they're releasing the final regulations soon. Sorry, this is nobody cares about this part. But so cookies will only matter if you need compliance with European Union, Canada, Australia, and then questionably California. So if you don't have to comply with those laws, you don't need to have a cookie consent checkbox. However, if you do, the most important thing behind GDPR and those other laws is consent. So you can't really collect people's personal information without them consenting to it. So you need to give users an actual choice. So if you have a cookie consent box that says, here's the cookies that we collect, and the only button that there is okay, that's not compliant. So there's a difference between essential and non-essential cookies. Essential cookies are cookies that are necessary for the operation of the website. That does not mean analytics. Analytics is not necessary for the operation of the website. That would be a non-essential cookie. So by default, if those laws apply to you, all non-essential cookies must be turned off. And then the user must be given a choice as to whether or not they want to accept the non-essential cookies. So essential cookies can be turned on your website by default. Non-essential, the user needs to be able to either agree or disagree with that choice. So you have to have yes or no. And if they click no, then non-essential cookies must be disabled. So I hope that answers that question.
Great, thanks. And I just want to say, in case people are needing to drop off, and that before you do go, but I want to continue this conversation as well, is that there's been a new YouTube channel been put together for, I think, the larger Chicagoland WordPress meetups. And I put a link in the chat box. So if anyone's interested, this will, Robert is recording this, and it will also be added there at some date. There he is.
That's actually a question I have for an attorney. Do we have to require consent for something like that?
Well, we're all located in Illinois, so we have no privacy rights.
All right. Yeah, there we go.
Unless you're collecting biometrics, in which case we do have rights. But nothing else, yeah. I did see Paul's comment that there is a session in WordCamp Europe talking about cookies. I would definitely recommend watching that one because it is by EU lawyer who specializes in privacy as well, so it's a good talk.
Hi, I have another question. This is Whitney from Cincinnati. Hi. So I'm working on one project for a rather small nonprofit organization, but they're probably going to be based in Indiana. So I think I would feel better if they were to speak to a privacy policy lawyer concerning this issue before I launch their site. Would it make sense for me to recommend that they speak to a lawyer based in Indiana or go to a service like Termageddon?
You can present both choices to them and let them make the decision themselves. So I know a lot of businesses, do want to work with attorneys and can afford it, and a lot of them can't. I think it's great to present both options and then, let them evaluate and choose what they need. I would definitely tell them to, Google search like privacy lawyer, Indianapolis, or wherever it is that they're located. And I'm sure they'll be able to find someone in their state. Or if not, I know a lot of privacy attorneys practice throughout the US, just because so many of state laws overlap and so many privacy laws apply to businesses outside of states in which the laws were passed. So they might even be able to get somebody outside of their state who would take that job too. But I would definitely say, allow your customer to make a choice, right? So, present both options and then they can evaluate and choose what's best for them.
Perfect. I was on your website and I saw that it covered informational websites, which is what that website is primarily going to be, but they also want to accept donations. Would you say that you also, I guess, specialize in nonprofits, or does the informational website that includes nonprofits?
So when you, and by the way, if you're an agency, you can go on our website and we have an agency partners page, and we'll actually give you a free license with a privacy policy, terms of service, disclaimer. So you can test it out yourself. We have an agency partners program, so you can kind of see how it works before you to decide whether or not you want to recommend it to your clients. But basically, when you start creating your policies, you'll answer some questions about your business. So what type of business it is. And one of the answer choices is not-for-profit. And then when, at the beginning, we'll actually evaluate which compliance you need. And it will ask questions like, are you a for-profit company? In which case some of the laws will drop off because we know they won't apply to you.
Okay, thank you very much. I'm not an agency, I'm just an individual. But
if you're a freelancer, we actually accept freelancers too. So I wouldn't be like worried about that part.
That's cool. Thank you so much.
Of course, of course.
Well, I certainly learned so much, Donata. It's very something I don't know a lot about, and I learned so much. Thank you so much for your time. And
yeah, absolutely. It's fun. It's fun for me. I know it's not fun for anyone else, but
sure.
if you do have any questions that you think of after this, feel free to email me. It's just donata@termageddon.com. And I'd be more than happy to answer any questions. I know it's a confusing and scary topic, but it doesn't have to be. It's just collecting personal information and having forms. That's when this comes around.